Welcome back. We're in Atlanta, Georgia, continuing our coverage in the racketeering trial of Jeffrey Williams, also known as Young Thug. The rapper, along with 5 other co-defendants, are charged with a multitude of gang-related crimes connected to the alleged street gang YSL, short for Young Slime Life. We're currently listening to a hearing outside the presence of the jury surrounding an ex parte meeting with witness Kenneth Little Woody Copeland. And he had crucial details in the case during this meeting that he discussed. Judge Glanville will have to decide if Copeland's former attorney, Caleb Bumpus, will be held in contempt for disclosing the hearing to defense counsel. So let's get you back into the courtroom so you can hear more about that hearing now.
All it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony, and the prosecutor and Pooley both indicated the promise was the prosecutor would seek to enroll Pooley in witness protection program if he were to in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed. Similarly, in this matter, the only thing discussed between the state counsel for Mr. Copeland and this court were the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to that were induced or sought by the court. And the transcript in its totality will bear that out, and you can have a look at that. The court's also considered Bruner versus the state. That's 302 Georgia at 6, and this relates to the right to be present and what is defined as a critical stage and under the Sixth Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present and see and hear all the proceedings which were had against him on trial before the court. Ward versus the state, 288 Georgia 641, pinpoint 645. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring a new trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. And that's Huff versus the state, 274 Georgia 110, pinpoint 111. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost, defense is waived, privilege is claimed or waived, or one in which the outcome of the case is substantially affected in some other way. And in this particular case, the court is of the opinion, basing on looking at the case law, that
all right. We know now that this hearing has been going on and the judge is reading what happened. And I still have with me trial attorney and Alexis Rosenberg and Paul Townsend, and they've been helping me go through all of this. Paul, I'm going to ask you, you're in the batter's box. The judge is still saying, look, I did nothing wrong. We didn't talk about substance, but in fact, they talked about immunity, that's substance. The one question I want to ask you is, what about Bumpus? What should she have done when she was in that ex parte meeting? And should she be held in contempt for actually telling Brian Steele, look, this is what went on? What should she have done?
Well, it's very easy to look back and say, oh, you should have done this, you should have done that. Should she be held in contempt for telling Brian Steele? Absolutely not. That's the ethical and moral thing to do, is to bring misconduct to the attention of the party that needs to voice it in order to actually address it and deal with it. This judge is very clearly just trying to stomp down on anybody who is attempting to challenge the power and authority of him to pretty much do whatever he wants, it looks like.
Exactly. Paul, hold that thought, because you're going to stay with me. You're both going to stay with me, but we have to take a quick break. Don't go anywhere. We're going to continue covering the Young Thug racketeering trial out of Atlanta, Georgia, and there's so much going on. Stay with us. We'll be right back. Wow, that was big. We've been listening to a hearing outside the presence of the jury surrounding an ex parte hearing involving YSL affiliate Kenneth Little Woody Copeland. And as a result, the show cause hearing for Copeland's former attorney, Kayla Bumpus, has been canceled, and Young Thug's trial is on pause until a different judge decides if Judge Glanville should be removed from the case. So with us are attorney and federal litigator Alexis Rosenberg and criminal defense attorney Paul Townsend. I have so many questions here. We were talking during the break, Alexis, about whether or not the judge is going to let his ego go by the side and backtrack on some of these decisions. And it seems like he is exactly doing that. He's taking no position on Bumpus, so no order to show cause. He seems to be saying that Attorney Steele did the right thing to raise these issues at the right time. I didn't hear him say anything about this contempt and whether that's been lifted. And the third big piece of information right there was someone else is going to decide this recusal motion. Tell me what you think about all those things. And Paul, you start thinking about that, because I'm going to ask you the same thing. If I have time, if not, we'll get it on the other side. Go ahead, Alexis.
Yeah, Terry, that's a lot to unpack. But first of all, I think somebody started reading the rules of the court and the rules of civil procedure, because we have him saying that another judge is going to determine and make a decision with regard to the motion to recuse himself, even though we have had several motions made to recuse this judge, and he has decided them himself and denied them. As well as we have that, which as attorneys, we've all been, what was the legal basis for the motion for contempt against Bumpus? So it's very interesting that he's walking away from that. I think he's taken a pause and really addressed that maybe he got caught up in some emotions when he was handling the situation, and now he really needed to start following the rules of civil procedure and the rules of the court again.
Exactly. And so again, Paul, my three issues, and it is a lot to have to talk about, what the judge is going to do as far as Bumpus is concerned. He didn't say much about what he's going to do as far as Steele is concerned, and this recusal motion. I really want to hear, I mean, I think he owes everyone an apology, frankly. I'm glad we're taking a pause, but he should do a little bit more than that.
I tend to agree. I think potentially what we're seeing here is the judge recognizing that maybe he acted a little bit rashly in the moment. Maybe he started throwing contempt accusations around and hearings around, and maybe when he had a minute, calm down. Maybe he spoke to somebody else in the courthouse. Maybe somebody got through to him and kind of said, "What are you doing?" And now he's kind of slowly backtracking and walking away from some of the decisions that he made. As you said, we don't know exactly what is to become of the Brian Steele contempt, but him taking no position on Caleb Bumpus is probably the right thing, because as we've noted several times in the last couple of minutes, we can't really see what on earth she would be held in contempt for. You know, he did kind of say that we'll let the Bar Association sort it out, as though there's some phantom specter of a grievance being filed against her or something like that. But it does seem overall that he is kind of taking a minute and going back to actual criminal procedure and trying to follow the appropriate steps at this point.
Exactly, and we're grateful for that. I don't know what's going to happen when the other court determines whether he should be recused, but that'll be interesting. And in the meantime, there's a pause on the trial, and fortunately, this is occurring during the July 4th, and hopefully it won't extend the time of this trial for much longer. All right, we have to take a quick break, but don't go anywhere as we continue covering the Young Thug racketeering trial out of Atlanta, Georgia. We'll be right back. right, we were just listening to little Woody Copeland on the stand. Alexis, I'm coming to you next. What would you do if you had to have a witness like this? He really doesn't want to answer these questions. He's very casual about it. She's been asking him to read certain portions, which he's had difficulty with. In fact, today he said, or the other day he said, listen, I have trouble reading, and still she wants him to put these documents and evidence. It's just been a very difficult witness for her to manage.
It has definitely been painstaking. He is not making out to be the great witness that she had so hoped for, obviously. You have to, the questions she's asking are not specific enough. She needs to ask him very specific questions so he has less likelihood of wiggling out. The questioning is very, lackadaisical, and it gives him the wiggle room to say, I don't know what you're talking about. No, we all know that looking at this, he is playing or appears to be playing, that he doesn't know, or, he doesn't understand the question. I think he understands the question, but she needs to tailor the questions. She needs to make that questioning more tight.
Absolutely. I think she's going to have to do even more than that. I think she's trying to be friendly with him, getting him to open up, but at the same time, I think he's taking advantage of all of that. All right, we have to take a quick break, but don't go anywhere because we're going to continue covering the case against Young Thug out of Atlanta, Georgia. We'll be right back. All right, let's talk about what's going on here with Copeland. And I have with me Alexis Rosenberg, Paul Townsend. Paul, I'm coming to you. You're a criminal defense attorney. You're sitting there listening to all of this. The prosecution is continuously asking questions about these pictures and asking him questions about who he knows. I mean, is he getting anywhere here by asking all these questions? Have we seen any criminal activity? I know these are multiple questions, but the thing way in the back of my mind is, I know you can't sue for malicious prosecution, but these defendants have been sitting here day after day, week after week, month after month, and nothing's happening.
Yeah, this is an example of a disastrous direct examination. If you look at what's going on, what Ms. Love is doing, she has a witness on the stand who is clearly not working with her. So she has a couple options. She can either streamline the questions, get to exactly what she wants to get to, and then get this witness off before he does more damage than good, which is what's happening now. Or she can just elect to cut her losses, get him off the stand, and move on. What she is doing by asking these ridiculously unnecessary questions of, when did you meet Thug's sister? When did you meet this person? Do you know this person? Do you know their name? Look at this photo. Who's in the photo? This is a waste of time. And the jury, who are already feeling extremely frustrated and tired of all of this, are going to look at this and say, why are you doing this? Let us just move forward. So I think ultimately, if you have a witness that you know is going to act like this, or that you think might act like this because you can't prep them, then you have to be far more concise and laser focused with what that person can give you. Get there, get them off the stand.
Exactly. It seems like every witness is on the stand for hours and hours and hours, days and days, and it's really going to wear that jury down. And I think it's going to end up meaning that the advantage is going to go to all of the defendants, as far as I'm concerned, because the jury is going to take it out against the prosecution that they've wasted so much time. All right, we have to take a quick break, but don't go anywhere as we continue our coverage of the Young Thug racketeering trial out of Atlanta, Georgia. We'll be right back. All right, little Woody's on that stand. Let's wrap this up for our viewers. Alexis, I'm going to start with you here. I mean, all of these names, how is the jury keeping track not only of the names, but the nicknames?
You need a flow chart. They really should break out that whiteboard and put it in front of the juror so you can see the nicknames with the regular names. But this line of questioning, it's better if she would put up the picture and say, do you know this person? How do you know this person? Is this individual also known by, their legal name? But I'm not following it. I really feel like I need to make a whole spreadsheet as to who's who.
All right, real quick, Paul, do you agree?
Absolutely. This is ridiculous. Little Woody is there to testify about this murder that took place. All we're getting is a series of, do you know this person? How do you know this person? When did you meet this person? It's completely irrelevant. It's a waste of time. Get to the point. Get to the point and move on.
Absolutely. It's a waste of time. The jury's not following it anyway. Listen, I want to thank both of you, Alexis Rosenberg, Paul Townsend. You've been amazing, and you've been a great addition to the show. And so we're going to take our break, and I'm going to excuse you, but you have to stay with us, because up next is the one and only Jesse Weber. So he's going to guide you through the rest of the coverage. Stay with us.